Hello viewers, this is Attorney Gehi and we are going to talk about a situation wherein someone has applied for an immigrant visa for you. An immigrant visa generally means that someone has applied for a green card for you and you went for your green card interview. Your brother sponsored you, your mother sponsored you, your father sponsored you, your spouse has sponsored you, and now you went for this interview, you went with all your documents, and the consulate gives you a letter when you go for the interview. And the letter mentions 221G of the Immigration and Nationality Act, which means that the consulate is telling you that we need more time to review the case. And now you went there, you gave them all the documents, and you're very disheartened. You're extremely sad because the consulate has taken a very long time. And you're kind of very much frustrated, especially because you made these great plans and your dreams are drowned right now. Your dreams have been drowned, especially because you sold your properties, you made all these preparations, you had this great party for your friends, and you said, I'm going to America. But when you went for that interview, the consulate officer tells you, sir, very good, I have your documents, but we need to investigate this case further. That's trouble, because it can dishearten you. And sometimes those queries can just take a couple of months, and most of the consulate officers are very good. They take a few months and they wrap it up for you. But there are times wherein you have been stranded in India for a very long time. You're stuck over there. And you're in India, you're sitting in Gujarat, you're sitting in Mumbai, or you're in Kerala, you're in Hyderabad, you're in Chennai, and you're kind of disheartened to see why this is happening to me. And on most occasions you're going to hear that get a congressman involved from the US, and unfortunately you get a letter from the congressman that this case is pending. Now, what are your options? There is one option which is only exercised by a lot of senior lawyers, and that's known as filing a writ of mandamus in federal court. So under 28 USC, under 28 USC section 1331 of the US code, one can apply for a writ of mandamus in the federal court. And the federal court is the only court that has jurisdiction wherein they can actually let immigration know to make a decision on your application. So now take an example, you're married to somebody and your spouse is in America right now, and you're stuck in India for a long time, or you sponsored your mother, you sponsored your brother, and at this time you're not hearing from the consulate, and if it has been nearly 2 years, and if you're close to the 2-year mark, you need to start considering the writ of mandamus. And through the mandamus, the good thing is that the federal court will have jurisdiction in those cases, and after that, if a federal action is initiated, then immigration will have to give an answer. Why are they holding up the case for so long? And if you think that if you have an open and a shut case, which means if you have a clear-cut case, then you should definitely consider filing a writ of mandamus, especially if your case is pending in India for more than 2 years after your interview. Thank you.